There you go. That's great.
Let's direct.
That's great. I can read the
You want me to fish you up a tripod for that?
thing on my screen.
You fucking dope. What the hell?
This is beautiful.
Hey, it's a couple pages. Do we want to string them
It's
out?
a lot of pages. I want
I
want the camera to get the off and everything.
It's true.
We're gonna do it carefully.
Yeah, we better do it carefully. I want 5 screenshots of every page on different devices.
5
I'm not fucking with this.
Good evening, boys and girls, friends and lovers, children of all ages, and welcome to night 44. Pueblo had it going up earlier. If you got to see Ghost Rider hanging, we're here with We the 303 at the occupation of the governor's mansion for change. We have come upon some court documents, and for your viewing pleasure tonight, we're going to unbox them. What do we got here? You want to read it?
Sure. Well, the plaintiffs are from 1203 Rockwood LLC, Linda McGregor, Brent Hammond, Ali Tufenper, and Matthew Woolbright. Defendant Jared Polis in his capacity as governor of the state of Colorado. You are hereby summoned and required to file with the clerk of this court an answer or other response to the attached complaint. If service of the summons and complaint was made upon you within the state of Colorado, you are required to file your answer or other response within 21 days after such service upon you. If service of the summons and complaint was made upon you outside of the state of Colorado, you are required to file your answer or other response within 35 days as such after service upon you. Your answer and counterclaim must be accompanied with applicable filing fee. If you fail to file your answer or other responses to complaint in writing within the applicable time period, the court may enter judgment by default against you for the relief demanded in the complaint without further notice. Dated July 9th, 2020.
This summons is issued pursuant to Rule 4, CRCP as amended. The copy of the complaint must be served with the summons. This form should not be used where service by publication is desired. Warning, a valid summons may be issued by a lawyer and it need not contain a court case number, the signature of a court officer, or a court seal. The plaintiff has 14 days from the date of the summons was served on keep the light. To obtain the case number. If the plaintiff files the case within this time, then you must respond as explained in the summons. If the plaintiff files more than 14 days after the date of the summons was served to you, the case may be dismissed upon motion, and you may be entitled to seek attorney's fees from the plaintiff. To the clerk, if the summons is issued by the clerk of the court, the signature block from the clerk or deputy should be provided by stamp or typewriter in the space to the left of the attorney's name. And this is a district court civil summons. We're going to untape this. By the way, this is posted on the gate of the governor's mansion here on 8th and Pennsylvania in downtown Denver, Colorado. Here we go. We got a third one there. And let's see if we can't get a piece of tape to hold itself up. That would have been the easiest way to do it. This piece right here. Oh, hold on. Let's just get this one right here. Let's go right there. All right. So, again, the attorney for the plaintiffs is John Finger of Pueblo, Colorado. District Court Civil Case Cover Sheet for initial pleading of complaint, counterclaim, cross-claim, or third-party complaint and jury demand. Oh, it's not even filled out properly. This cover sheet should be filled with the initial pleading of a complaint. That means it's actually supposed to be rewritten. Failure to file this. Oh, well, let's see. Hold on. Maybe not. Those are instructions. I want to get to the meat and potatoes of this. Boom. There we go. Complaint for injunctive and declarative relief and damages. Ooh, I like these kind of complaints. In March 2020, Colorado's Governor Jared Polis began issuing a series of executive orders as his way of responding to the coronavirus pandemic.
Of course.
4 of those executive orders have banned or restricted evictions and writs of restitution under CRS 1340-101. All 4 of those executive orders cited Article 4, Section 2 of the Colorado Constitution and CRS subsection 24 33.5 701 as the governor's authority to issue these orders. All 4 orders are invalid.
Whoops.
The first executive order, D 2020-012, issued March 20th, Exhibit A. I am temporarily limiting evictions, foreclosures until April 30th. The same order banned landlords from imposing late fees or penalties for payment and non-payment of rent. Directed the executive director of the Department of Public Affairs and Safety to work with sheriffs and mayors and local leaders to take similar formal actions with law enforcement agencies to suspend residential evictions. Okay, so somebody's not happy about the eviction order, and they're saying that it's illegal. These are people who are saying that you must start evicting people, I bet.
Yeah, that's exactly it.
Until April 30th, 2020, such actions are necessary to protect public health and safety. These actions effectively eliminated any landlord's ability to initiate or continue with any eviction proceeding for non-payment of rent or any physical eviction by any sheriff resulting therefrom. The second executive order, D 2020-051, issued April 30th, Exhibit B. No individual shall do the same things, limiting the evictions until April 30th. Till when? Premise based upon a tenant's default of any contractual obligation imposed by a rental agreement. Parts M and N of that executive order prohibited judgments for possession and removal of a tenant or the exclusion of a tenant from the property based on a writ of restitution. So Part B contained the prohibition of the change of late fees due to non-payment of rent. That order was due to expire 30 days from April 30th, 2020. The third order was May 29th, and the language was only slightly different. Banning evictions in the default is caused by financial hardship due to COVID-19. These bans enforcing judgments for possessions and writs of restitution were likewise extended 15 days past May 29th. The legislature, which was suspended from March 14th, returned to work on the 26th of May. Proponents continued eviction pause, introduced the relief for residential and small business tenants in response to COVID-19 Disaster Emergency Act of 2020. The bill would have continued the ban on evictions past the end of the prohibition stated in Executive Order E 2020-88. After consideration, the legislature refused to pass the bill before the last day of the legislature on June 12th. The next Saturday, Governor Polis disregarded the role and will of the legislator, according to the plaintiffs in this service, and he rewrote the law himself, signing the fourth executive order, 101, and that's Exhibit D. This suspends CRS 3812-204, 38 sections 1 and 204.3 section 2, requiring landlords to provide tenants 10 days notice for any default for non-payment rent, returning to which time the tenant has the opportunity to cure the default. Landlords must provide tenants with 30 days notice on any default for non-payment before initiating or filing action for forcible entry and detainer. Such 30-day notice may extend beyond the expiration of the executive order. During this 30-day period, tenants shall have the opportunity to cure any defaults, so actually pay their bills for non-payments. So if you got caught up and you paid your bills, and you should be fine with your landlord, and there should be no problems.
Oh, the governor's trying to quell the homelessness.
He is trying to quell the homelessness. The order does not state whether landlords who had... Oh, wait. Maybe he's just trying to look like it.
Yeah.
The order does not state whether landlords who had previously posted a 10-day demand had to restart the process. It also doesn't state whether his order applies to cases where a 5-day demand is required under CRS 1340-104 or commercial leases where a 3-day demand is required. Once again, Governor Polis prohibited late fees, this time from May 1st, 2020 through June 13th, 2020. Having signed the order on Saturday, Governor Polis did not give any landlords in non-payment cases, some of whom had been waiting over 3 months to file eviction, a chance to do so. The order is due to expire 30 days from June 13th, but the 30-day notice may extend beyond the term of the executive order. The order is so broad,
So broad.
that it even allows millionaires and billionaires who have not been affected by COVID-19 the ability to defer payment of rent to a struggling landlord and not pay late fees. Now that's kind of bullshit, okay? Because if you got the money, fucking put it into the economy, okay? And if you're wealthy as fuck, then you should pay your bills. Plaintiff 1203 Walkwell LLC, a Colorado limited liability company, owns real property in El Paso County, Colorado. Plaintiff has a contract with the tenant at this location requiring the tenant to make monthly payments. The tenant has failed to pay the rent for the last 6 months, and at the date of this filing, owes over $8,000 in rent. $2,000 a month. That's what my house runs. Late fees and other damages. Damages continue to accrue. The plaintiff posted a 10-day demand for compliance notice and has made numerous attempts to collect rent from the tenant. The tenant continues in possession, is well aware of the continuous set of executive orders issued by Governor Polis, and refuses to pay rent. The plaintiff must nonetheless continue to make payments on the underlying debt, taxes, insurance, and maintenance. The plaintiff has been harmed irreparably by the orders of Governor Polis, which have effectively barred plaintiff from seeking adequate remedy in court. You're right. Damages continue to accrue. Plaintiff Linda McGregor owns a real property in Teller County, Colorado. Plaintiff had a contract with the tenant at this location to pay monthly rent of $1,200. With one exception, plaintiff's tenant has refused to pay rent since April 15, 2020, when plaintiff posted the 10-day demand for compliance notice. Plaintiff has attempted on numerous occasions to obtain the rent from the tenant without success. The tenant continues in possession, is well aware of Polis's orders, and caused property damage, destruction, changed locks, refuses to allow maintenance or inspection of the property, discharges firearms, refuses to reimburse plaintiff for propane charges, accumulates trash, and causes other nuisances. Plaintiff has been irreparably harmed financially by the order of Governor Polis, whose orders have effectively barred plaintiff from seeking an adequate remedy in court. As of the date of this filing, the tenant owes $2,900 late fees plus other damages. Damages continue to accrue. Plaintiff Brett Hammond owns real property in El Paso, Colorado, and has a contract with the tenant at the location for the tenant to pay a monthly rent of $1,600. Due to the governor's continuing executive orders, plaintiff was unable to collect rent and must instead return to starting eviction based on a notice to quit. The tenant refuses to pay the monthly rent. She continues to reside in the property now. As of the date of the filing, tenant owes $6,400 late fees and other damages. Her non-payment of rent has resulted in irreparable financial hardship for Mr. Hammond. Damages continue to accrue. Number 10, plaintiff Ali Taufinpur owns property in El Paso County and has a contract with the tenant location paying $2,700. Plaintiff has sought rent from his tenant, but the tenant refused to pay, knowing Governor Polis's executive orders. The answer is getting shorter, okay? They continue to reside in the property, and $5,400 plus late fees and damages are accruing. Matthew Wilbright owns property. His lease is only $1,000 a month. Must not be a great property. Plaintiffs have sought rent from the tenant, but the tenant does not pay, and
Refuses all
he refuses all communication. Because if you can't talk to me, you can't serve me. I can't be legally liable. That's part of the answers. The tenant has allowed unauthorized progress and animals to occupy the unit. I don't know if these are cats, dogs, or raccoons and squirrels. Okay, maybe he's the next lion.
He's got a
what's the
crocodile
the
farm.
Tiger
King.
Tiger King. Yeah, maybe he's the next Tiger
What's up, all
King.
you cool cats and kittens?
But he's got animals on the property, and they occupy the unit. The occupant's use has caused water damage to the unit underneath that of the plaintiff. Oh, so the tenant's above the landlord in this situation. Wow, it's really funny how the light flashes on the sign.
Yeah, I'm
So,
trying
yeah, you're good. Neither the local health department nor the local police will assist. Okay, see, this is where they're under orders and under instructions not to do a damn thing, and they're not helping. So for non-payment of damages by the occupants, combined by the Governor Polis's prohibition, exposition, evictions for non-payment of rent, there's irreparable harm to Mr. Woodbright.
Hey, I might need to take this over there.
I think they're just trying to move a car. We're gonna hold on to this for a second. The return of the service was scheduled for. Okay. So as the day of the filing, the tenant had $7,600 and $7,649.18, not including late fees and the pain in the asses and all the other shit that they want to get off. That's the chief medic.
Bobby? Oh.
The service for March 24th, 2020 was continued due to Polis's executive orders. The service has not occurred. Plaintiff's damage is occurring. The plaintiff has no indication whether the case must be refiled, and you must post a new demand, or if the duration thereof, or if so, the duration thereof. None of the plaintiffs in this case is able to market his or his respective property to a replacement tenant or mitigate their damages. So basically what that's saying is they can't find somebody else to live in the space. They can't fix the property to make it bring it back up to code so they can rent it, because the people that are in it aren't coming out, and the property's so damaged and it costs it slam on people, right? So
Sounds
the
like we're all out of money.
right. So jurisdiction and venue. Plaintiffs incorporate by reference the above allegations as if set forth. The court has jurisdiction over the parties upon information. Oh, so the court's jurisdiction. Plaintiff has agreed to consolidate the Teller County case with other cases. Here's some state statute: International Shoe versus Washington 326 U.S. It's about combining cases together. Other information: no party to this litigation is the military service, and all are engaged in civilian occupations. First claim for relief: violation of the separation of powers. Plaintiffs incorporate by reference the above allegations as set fully forth herein. The judicial, executive, and legislative powers are separate. So basically what they're saying is that the governor used his executive orders to declare rules for the judicial branch, and that because there's a separation of powers, the governor cannot tell the judges what to do, and there's a checks and balance system, and so that's what their plaintiff their order claim for relief is under. Judicial review has been well established since the decision of Marbury v. Madison, 5 U.S. 137, 1803. Now, remember this is important, because when you're going back in case law, 1803, 117 years ago, 217 years ago, is standing law. And if you want to know why you have a legal ability to carry cannabis that you bought legally with a prescription from one state to a non-prescription state, it's the most horrible legal establishment that you could possibly imagine. And it's why they were able to take slaves from one state where slavery was legal into a state where slavery was illegal, and still bring the slaves back to the state and claim them as their property, and they never lose it. And that's the same reason that you can legally stand on carrying marijuana state to state right now. It's disgusting,
That is fucking nuts.
isn't it? But this is the old law, right? 1803 is the case they're citing, right? And you want to talk about constitutionality. Article 3 of the Colorado Constitution prohibits one branch of government from exercising powers of the Constitution. You want me to hold that for a minute? Come over a little bit over that way. Yeah. Of the Constitution vests on another branch. So again, if the legislature doesn't do something, the governor can't override the legislature, and the governor can't give instructions to the judges and tell them what they are ordered to do. And that's what the complaint is saying, basically. And I kind of have to agree with this, sadly, because the legislature should have passed some legislation about rent relief, about mandating banks to alleviate overage fees, and even possibly mandating that they apply forgiveness to mortgages across the board because they've been bailed out and financially it's their turn to do that in return. So here's this. CD Enterprises versus Indus Claim Appeals Office of State of Colorado, 89 P3D 430 and 433, Colorado Appeals 2003. The governor's authority when it comes to issuing executive orders that go beyond the administration of government and call for actions that affect private citizens by force of law is limited by enabling legislation. So I'm going to break these down for a second, because in issuing executive orders that go beyond the administration of government, is the administration of government preventing a pandemic? If that is the administration of government, it may not have gone beyond those outreaches, right? So he may not have stepped beyond those bounds. And it may then also be within his bounds to order rent forgiveness, right? But he's failed to do so, and that opens him up to this lawsuit that's standing here. So, Colorado Polytechnic College versus State Board 476 PD2 38, Colorado 1970. It is the province of the legislature to enact legislation and the province of the executive to see that laws are faithfully executed. Colorado Assembly v. Lamb 704 P2D 1371 1380, Colorado 1985. As such, and concluded by the Office of Legislative Legal Services, the governor lacks authority to formulate policy or impose requirements beyond regulating the internal workings of the executive branch. So the governor lacks authority to formulate public policy or impose requirements beyond regulating the internal workings of the executive branch. That means that he's supposed to be limited, and the legislature is supposed to take certain roles. And the judicial, again, it's checks and balances system.
So they're saying his executive orders were
Unconstitutional and illegal.
Hey, can you find
Okay.
someone with a flashlight?
interesting.
Uh-huh. The lawsuit's being followed, right? So how soon will the governor get evicted? That's a good question. I don't think that's going to happen. But we're here to do that, possibly. So
Move in.
you'll move in. It's a nice place. I'd share a bed.
I hear they have a garden.
I garden. I definitely garden. I bet you the soil's good too, not too full of clay and anything. So
Hey, 2 seconds.
in each of the executive orders of this litigation, Governor Polis cites Article 4, Section 2, and CRS 24-33.5701 as his authority. Article 4, Section 2 of the Constitution reads as follows: Governor, Supreme Executive. The supreme executive power of the state shall be vested in the governor, who shall take care that the laws be faithfully executed. Note that the language of the section says that the laws will be faithfully executed, not promulgated by his own whim. Each word is intentional, and it must be taken individually and as the whole and sum.
The word whim is interesting to me there.
Well, you know, we could just be nilly-willy about our actions.
True. About evictions.
About evictions, yeah, we'll just do it nilly-willy. Right? We'll evict the...
Nilly sounds fucking better.
Oh, here's this a light for me to hold? I can do that.
Does that work?
Yeah. Does that help?
We got some stuff to do.
We still got some stuff there. So, yeah, absolutely.
Are you good?
Yeah. Fucking fantastic. CRS 2433-5701 is the Colorado Disaster Emergency Relief Act, named Act. The act was passed before the current pandemic and established the framework under which the governor could operate in the event of a disaster, including disease epidemics. The act provides that the governor may declare by executive order that a disaster has occurred and that this occurrence thereof is imminent. The state of the disaster emergency shall continue until the governor finds that the threat of danger is past and that the disaster has been dealt with to the extent that which emergency conditions no longer exist, and the governor terminates the state of disaster emergency by executive order or proclamation. But no state of disaster emergency may continue for longer than 30 days unless renewed by the governor. The specific powers granted the governor to respond to the declared emergency are enumerated under CRS 2433-5704, Section 7. In addition to any other powers conferred upon the governor by law, the governor may suspend the provisions of any regulatory state prescribing the procedures for conduct of state business or the orders, rules, or regulations of any state agency. If strict compliance with the provisions of any statute, order, rule, or regulation would in any part prevent, hinder, or delay necessary action in coping with the emergency. Suspend the provisions of any regulatory state statute. Yes, no, I understand that. I'm trying to break it down. I want to unbox it, right?
Okay.
Because the procedures for conduct of state business is evictions, is making sure that money is flowing, that property taxes, that landlords are paid their bills, that evictions happen, the courts operate, things like that. So he's suspending the provisions of a regulatory statute prescribing the procedures for conduct for state business. But the state agency, the judicial courts, is not a state agency.
Judicial courts. Who runs
It's
the
judicial branch. They're their own. They're run by the Supreme Court. They're a separate agent. They're not the state agency. They're their own thing. So what they're saying here is that they're restricting of the courts is not an agency that he has the power to restrict.
Interesting.
Okay. Utilize all available resources of the state government and for each political subdivision of the state as reasonably necessary to cope with disaster emergency. Semicolon. Transfer the direction, personnel, or functions of state departments and agencies or units thereof for the purpose of performing or facilitating emergency services. Subject to any applicable requirements or compensation under Section 24.3.5-711, commandeer or utilize any private property if the governor finds this necessary to cope with the disaster emergency. So if the disaster emergency says that people get to stay in their houses rent-free, the governor has to declare that, and there's probably some methodologies that require compensation for such declaration and commandeering of.
Like a stimulus check?
No, like a stimulus check, but if the governor says you can't evict people because they can't pay the rent, then he has to pay the rent.
Oh. Well, hey, Polis, I have rent to pay.
Oh, this is so fun. Okay. So, this is just what I'm reading, right? So, I could be wrong. I'm not a lawyer. I don't get it all. But direct to compel the evacuation or any of all part of the population from any stricken or threatened area within the state if the governor deems the action necessary for the preservation of life or other disaster mitigation, response, or recovery. prescribe routes, use of modes of transportation and destinations to coincide with the evacuation, suspend or limit the sale, dispensing, or transportation of alcoholic beverages, firearms, explosives, or combustibles. Oh my God. Do you know what that means? Do you know what that means?
What does that mean?
He does not have the power to suspend or limit the sale of marijuana. It's not in writing.
I say we spark one up. Just kidding.
None of the powers. Okay. So, see, this is why we read shit. This is why you got to pay attention. Because that's like, that just stands out to me. Do you have a lighter?
Yeah.
It's a pinner.
Oh, fuck yeah.
It's good stuff, though.
Oh, it's thick.
It is thick. Make provision for the availability and use of temporary emergency housing, which is what they did for the homeless, right? And
Did
I do tell jokes sometimes.
Sorry, I'm all about jokes. But anyways.
It's good. Suspend the limit sale, dispensing, or transportation of alcoholic beverages. Yes. Determine the percentage at which the state and local government will contribute monies to cover the non-federal cost share required by the federal Robert T. Stafford Disaster Relief and Emergency Assistance Act, as amended 42 U.S.C. Section 5121 et sec. Required by the Federal Highway Administration pursuant to 23 U.S.C. Section 125, or required by any other federal law in order to receive disaster relief funds. After making such a determination, the governor may amend the percentage at which the state and local government will contribute monies to the non-federal cost share based on the needs of the individual local governments. As soon as practical, after making or amending such a determination, the governor shall notify the Joint Budget Committee of the source and amount of the state monies will be contributed to cover non-federal cost share pursuant to this paragraph. None of the powers conferred under Article 4.2 or CRS 2433.5.701 even comes close to conferring a power upon the governor to suspend evictions or the writs of restitution resulting therefrom. Take like half, huh? The argument above alone is sufficient for the court to declare that Governor Polis acted ultra vires and to nullify the executive orders. I don't know what ultra vires is, but folks, I hope you'll be...
I can Google it, but keep going.
The executive orders shut down another branch of government, namely the judicial branch. See, I told you that was coming, right? I love how this shit works out. Landlords such as the plaintiffs who would pursue rent from their tenants have been unable to use the only lawful system available to them in order to preserve their rights, namely the court system. Under the order, judges have lost the ability to use their discretion and consider the facts of each case. Therefore, judicial discretion has been replaced by executive order. The executive orders are in clear violation of the authorities cited infra. All of the executive orders usurp the powers of the legislature in that only the legislature has the authority to enact legislation affecting landlord-tenant law, which they failed to do.
Okay, do you want to hear, about ultra vires?
Yes.
Okay, it's a Latin word which means beyond the powers. It's used in law to describe an act which requires legal authority but is done without it. Its opposite, an act done under proper authority, is intra vires, within the powers. Acts that are intra vires may equivalently be termed valid, and those that are ultra vires are termed invalid.
Okay. So they're
Thanks,
arguing.
Wikipedia.
Yeah, they're arguing whether he had the authority, basically. And they're saying he had no authority. But the legislature has such authority to enact legislation affecting landlord-tenant law. The fourth executive order is especially egregious by suspending the law, these statutes, and Governor Polis unlawfully nullified statutes which were duly passed by the legislature. That's 3812-2041, 3812-20432, and 1340-1041D. Polis unlawfully nullified statutes that were duly passed by the legislature and signed into law, and then invented his own arbitrary 30-day notice requirement. Interesting enough, Polis himself signed the latest versions of the statutes into law. So he signed the laws and then he nullified them, basically. So there's a second claim for relief here, and the holy shit.
Yeah, I'll
Are we
start
like
reading
seriously?
if you want a little
Okay.
brief. Yeah. So, the second claim for relief is the abuse of powers, the ultra vires. So, plaintiffs incorporate by reference the above allegations as if fully set forth herein. On March 25th, 2020, Governor Polis issued Executive Order D-20-017, the so-called stay-at-home order, citing the same authorities stated infra. This order mandated that Coloradans stay home with certain limited exceptions. Governor Polis issued this order under the guise that we must take additional action to minimize the duration of this epidemic and that disruption to our daily lives. The virus that causes COVID-19 is spread primarily by close contact between people and through respiratory droplets when an infected person coughs or sneezes. At the time, Governor Polis concluded that COVID-19 was such a threat that people must be ordered to stay home. Executive Order D-20-017 expired April 11th, 2020 and was not renewed. In the Safer at Home order which followed, Executive Order D-2020-044, Governor Polis admitted, we have seen indications that our efforts to flatten the curve are working. The purpose of that executive order was to allow many Coloradans to return to work while we maintain a sustainable level of social distancing. Indeed, the numbers have shown that there has not been a spike in the number of COVID-19 cases in Colorado since the Safer at Home order was issued. I feel like that's no longer true.
There's a climb, but not a spike.
Okay. Since the order was issued, the 7-day average of cases based on the reporting date has not returned to the level seen in mid-May 2020, and death rates from COVID-19 have continued to decline. Under the Coronavirus Aid, Relief, and Economic Security Act, CARES, Public Law 116-136, most Americans have received a check or deposit in the amount of $1,200 from the U.S. Treasury. Those who have lost their employment due to the pandemic have received an extra $600 over and above their weekly unemployment benefits. This strengthens tenants' ability to pay their financial obligations, such as rent. Governor Polis himself has authorized the reopening of places of worship, restaurants, pools, theaters, storefronts, and other businesses. Most businesses which have not shut down permanently as a result of the governor's orders have been free to reopen without certain restrictions. Yet landlords are still expected to carry the burden for those who don't pay their rent. Governor Polis likewise has no power to prohibit late fees under the authorities he cites. Late fees are important to ensure that tenants punctually comply with their lease obligations. The landlord's obligations don't wait for a tenant to casually decide when to pay his or her rent, or their. Landlords such as the plaintiffs have expenses such as mortgages, taxes, insurance, utilities, and maintenance which don't wait because tenants don't pay their rent. The defendant's prescription of late fees is arbitrary and unlawful. Alternatively, if Governor Polis did have authority to halt or limit evictions, late fees, and writs of restitution by way of executive authority, the plaintiffs do not concede such authority ever existed. His authority expired with the expiration of his stay-at-home order on April 11, 2020, and any action taken by the defendant subsequent to that date should be declared ultra vires. People were no longer confined to their homes and could go about their business, allowing them to work and pay their rent. Any emergency authority Governor Polis had at the beginning of the crisis expired with his stay-at-home order, and he no longer has any authority to act under the authorities he cites in his executive orders. As a result, the second executive order should have expired by law on April 11, 2020, and the third and fourth orders should have never been issued. All of the executive orders, and especially the third and fourth, are an abuse of power vested in the governor. Wherefore, plaintiffs move the executive orders may be declared null or void for fees and costs and for the relief of the court may deem appropriate. Other relief.
Okay, third claim for relief, unconstitutional vagueness. Plaintiffs incorporate by reference of the above allegations as if fully set forth herein. Governor Polis' third of executive order is unconstitutionally vague. If the default was caused by financial hardship due to COVID-19, how is the landlord to know, and at the time of filing, whether the tenant fails to pay rent due to financial hardship? How is the landlord to know if the tenant with financial hardship has suffered hardship due to 19? And whose responsibility is it to put such information in his or her pleading? Governor Polis' fourth order is unconstitutionally vague. By example, the order replaces 10-day eviction notices with 30-day notices, a number arbitrarily chosen by the defendant. It is unclear if a 30-day notice is now required in a commercial eviction, where a 3-day notice is currently required, or an exempt residential eviction, where a 5-day notice is currently required. It is unclear whether landlords who served a demand notice before the date of the fourth order must restart with a 30-day notice, and whether they would be allowed to file evictions if they actually waited 30 days from serving the demand notice to file their lawsuit.
Wait, can I ask a question really quick?
Yep.
So, 5-day notice?
Yeah, for commercial properties.
Okay.
Right. So if you were a restaurant that hasn't paid their rent for 30 days and the landlord has a new tenant to come in, he has the right to give you 5-day notice with an eviction status to basically say, pay in full or get the fuck out of here.
For a whole ass restaurant.
Yeah.
Damn.
Oh yeah, shit's fucked up. But there's reasons for it, right? Because if you're running a business and
You can't pay your rent.
you can't pay a rent, that's not fair to the landlord as well. And I mean, I get it. Like, look, I live in a 120-year-old home, and we pay $2,000 a month for our rent, right? That's a lot, maybe more. Utilities, all that shit, right? It's not up to par. It's not clean and foundationally all the things tended to, right?
You probably do work on the house yourself.
Yeah, and I've only been there like 30 days. So the fourth order is vague. The 30-day notices are there. The 5-day notices are there. And it's unclear whether cases filed before the date of the fourth executive order.
Must.
Oh, yeah, I gotcha. Must restart, or whether they must restart with a new notice of some kind, or whether they must be refiled. It's unclear as to what happens in cases that were filed before any one of the orders were issued. So if you didn't have COVID and on March 10th your landlord filed an eviction notice, and on the 17th of March the courts closed and that process never happened, is the process of eviction supposed to be legal from the first filing? And do they just have to get back on the docket and make it happen, right? What's the legal standing here? So these are good questions. And finally, the 30-day notice required in the fourth executive order has no end date, merely stating that it may extend beyond the expiration of the order, leaving the population to guess when it might end.
Mm-hmm.
That provision alone makes the population must accept something as a law which has neither been passed into law nor has even the backing of an existing executive order, nor has a certain end date. So basically it's like, we're just going to do this shit forever, right? And they're like, well, that's not legal. They might be right.
Well, it was supposed to end in April, but this crisis is still kind of happening, so
Yeah,
who knows?
it's a real thing. Oh God, there's God.
Okay, so we're going to get through these last pages. The constant renewing of executive orders impacting evictions leaves landlords with no foreseeable end that would allow small landlords, such as these plaintiffs, to properly plan and organize their affairs. If you want to tell First America Bank that you can't pay $15,000 a month because 8 of your properties are not collecting, and you're going to lose all of them to the corporation eventually, right? So there's a reason that they're saying this. Plaintiffs remain in a continual state of limbo and uncertainty, while Governor Polis is maintaining that in each executive order that these restrictions are temporary. The restrictions have, in reality, been renewed 3 times and counting with no end in sight. The orders challenge the plaintiffs are too uncertain in duration to be fully litigated prior to cessation or expiration. And there is a reasonable expectation that the plaintiffs and other landlords will be subject to these or similar orders ad infinitum forever at the of the next flu season, or if there's a second surge in COVID-19. For the reasons and for other claims, we're alleging that the complaint should not be mooted and should be resolved now, even if the current order changes or ends. Spencer v. Crema. So basically, they're saying you can't. It's not important because it changed again. You gotta make a decision.
Are they saying that because we've received stimulus checks?
Yes.
And that because COVID isn't actively growing right now,
Yes.
that rent and
Yes.
evictions are
Dispensaries are open and you can all go buy your weed. Then you should be able to pay your fucking rent.
Okay. Just clarifying. Thank you.
Just saying, right? I mean, it's a valid point. If you can go buy
If you
pot.
can buy weed, yeah. But Polis can't take your weed away.
No, we can't because you can grow your own weed.
True.
So, the essential inquiry in addressing a void for vagueness challenge is whether the statute forbids or requires the doing of an act in terms so vague that persons of ordinary intelligence must necessarily guess as to its meaning and to defer to its application. Yeah, it says it's vague. It is vague. I'm sorry. People v. X. Rao Rain v. Meager, Colorado 2020. Gross 830 PD P2D 933 937 Colorado 92. Quoting People versus Becker 759 P2D 2631 Colorado 1998. Polis's 4th executive order isn't even a statute. It should therefore be subject to a higher standard of scrutiny than a statute, as is the will of one person. It has the courts and litigants guessing as to its meaning and application, whereas plaintiffs move that the 3rd and 4th executive orders be declared null and void for vagueness, for fees and costs, and for the other relief. And there's a 4th claim. And
it is a violation of the First Amendment rights of the U.S. Constitution.
oh shit. People, I'm tired.
We are tired. Should we take a short break?
No, because it's not going to continue.
Okay,
I won't finish
all right.
it, but I'm gonna read it and surmise it. So, 4th claim for relief, violation of First Amendment. No. The plaintiffs incorporate. Hold on, by reference. Full set forth. First Amendment provides Congress shall make no law abrogating the right of the people to petition the government for a redress of grievances. This is a redress of grievances. Grievances are, in fact, filing of motions saying, hey, this person isn't paying their bills. So, yes, keep going through the 14th flip. Amendment says that DeLong versus Oregon, the right has the roots in the Magna Carta and has long been viewed as a fundamental and inviolable right. So the summation of this is real basic. If you can't address the courts to file a grievance, then the reason why you're not allowed to file grievances is constitutionally invalid. The grievance could be it's grievance. So the 6th claim for relief is a violation of the 5th Amendment, which says that private property should not be taken for public use without just compensation, right? So basically, if the people don't have to pay their rent, the government should. I said that earlier, okay? Most restrictions for the use of private property do not constitute a taking. When a governor's executive order substantially restricts the owner's use of the property so that the regulation goes too far, it may be deemed a regulatory taking of the property for a public use. And if it's taking, then the government must compensate for what it took. The operation of the defendant's orders, fairly read, is that the rental property owners have no legal recourse or enforcement remedies to remove or collect their rents. That's the same for rentals. So go ahead. Next page. There's a few more arguments. But the sixth claim of relief is the 14th Amendment. Same arguments. He set up the economy, and he didn't close the gaps. I'm really losing it.
It's okay, we're almost there.
In his first executive order, Polis encouraged but did not require financial institutions to make a 90-day deferment. In subsequent executive orders, he doesn't bother to encourage such cooperation. It was left for landlords to fend for themselves and to hope and pray that they will remain solvent without legal remedy to deal with non-paying tenants.
They have a night job. Anyways, okay.
I'm on the night job right now.
We are.
Right?
We're
we
here.
are.
It's night
We
shift.
should do some dabs. That would definitely wake my ass up.
You think? Dabs put me to sleep. Okay. The orders have suspended a contractive law as it applies to the landlord-tenant relationship. The landlord's rights have been impeded, but the obligations have not diminished. They're still liable under the warranty of habitability for repairs, pest control, utility payments, cleaning, trash removal, security deposits, just to name a few. Nothing in Polis's orders stop a tenant from taking the landlord to court to enforce the landlord's obligations. Yet landlords cannot take a tenant to court to enforce one of the tenant's biggest obligations.
Ooh.
Damn. That's
So
rough.
if you have to pay Denver Water because your tenant uses the water and it can't be shut off because of a pandemic and needs to clean, do you, the landlord, have a requirement to pay the bill? And if so, that's an unfair burden that the government cannot legislate on people. Wow, that's real.
Prospective tenants who are ready, willing, and able to pay rent have been supplanted by those current tenants who do not pay rent. Such prospective tenants likewise receive unequal protection due to Governor Polis's orders, and they cannot find suitable housing due to that housing being occupied by non-complying tenants. Due to a chronic housing shortage in Colorado, and especially on the Front Range, this unequal protection is even more acute. The purpose of the Equal Protection Clause in the 14th Amendment is to secure every person within the state's jurisdiction against intentional and arbitrary discrimination, whether occasioned by express term of statute or by its improper execution through daily consulted agents. That's from Village of Willowbrook versus Olek, 528 U.S. 562, 564 from the year 2000. Plaintiffs move that the executive orders be declared null for the relief of the court.
Right?
Okay.
And that they pay all the legal expenses.
Yep.
All right, where are we at here? Holy shit.
We probably have like 5 pages left or something.
Okay, so the eighth claim of relief is for interference with contractual relationships. They're going to Article 1, Section 10, Clause of the United States Constitution, no state shall pass any law impairing the obligation of contracts. Except that there's dots through all this, and that's kind of bullshit and bogus. Home Building and Loan Association versus Beisdell. Nothing can be more material to the obligation than the means of enforcement. The ideas of validity and enforcement are inseparable, and both are parts of the obligation, which is guaranteed by the Constitution. Except for that damn T, that wasn't guaranteed by the Constitution. Defendant intentionally and unlawfully interfered with contracts, negotiating and negating the obligation for them and the ability to create redress. The rights to evict and declare contractual default are core to every residential commercial contract. Contract is the way of the West. Whiskey is for drinking and water is for fighting. There's a ninth claim for injunctive relief, which means stop it now. Let's evict everybody, let them kick the fuck out of their properties. We want our space back. We want to rent to people who pay their bills, who are wealthier and richer. We don't give a shit about the homeless. The COVID crisis may or not be real anymore.
The cost of housing in Denver is skyrocketing.
The courts can see that this is really just a bunch of people with a story to tell, and they're not paying their bills. And the 10th claim is for the attorney's fees. Yep, next page. So basically, you have to type in that the attorney has to be paid, and here's how much they need. So there's percentages. That's it. That's basically. There's plaintiffs in there. There's separation of church and state. It's beautiful. I thank you so much for taking the time to cover me. I'm so dead though.
You need to go to bed.
I'm going
you have
home.
To be up early.
Yeah, we gotta get food and feed the homeless, and the poor and the community.
And the people who are getting evicted.
And it's midnight already, so it's time for me to go to bed. For sure. Thanks for hanging out, folks. Have a great night.